Yes.
Hi, Paul Johnson again. I had a question, I guess, on a matter that Professor Amar touched on briefly, the citizen clause of the 14th Amendment. I'm kind of interested in what does it really mean to be a citizen? And it seems to me that the right of citizenship is the vote. So I'm wondering if the 15th Amendment as a legal constitutional matter, not a political matter, but legal matter, was clarifying or redundant.
It could conceptually be. We do have clarifying clauses of the Constitution. I did a piece in the Valparaiso Law Review called Clarifying Constitutional Redundancies and Clarifying Clauses. And history is going to be really relevant here. When you just look at the text, you can't always tell. But when you look at the history, the Federalists say the necessary and proper clause is clarifying or redundant. They admit that the 10th Amendment is a declaratory. It's a textualization of something that's already in the thing. No one, not a single politically relevant person that I know of, thinks that that's true of the 15th Amendment. There's no prominent supporter of the 14th Amendment that I know of that says that this is about voting. Many who say it's the exact opposite. And Steve told you one reason why, because there's a connection to, because you can say, well, where does it say in the text, Professor, civil rights? And he said, one, it's a companion to a statute whose very whose very title is the Civil Rights Act of 1866, in contradistinction to political. You have to know what's in and what's not in, civil as opposed to political. And then he said, and look intratextually, and it's linked to Article 4, and here's one thing that I don't get when I come to Pennsylvania. I get the same right to sue and be sued and own property and all sorts of civil rights with Pennsylvanians when I, as a Connecticut person, come down here, but I don't have under Article 4 an equal right to vote or serve on a jury or serve in a militia or hold office. And so there are a whole bunch of, and you're a citizen from the day of your birth, and you don't vote, and women are citizens, and they can sue and be sued in diversity jurisdiction, and that's what the dissenters say in Dred Scott, but they don't merely by dint of their citizenship have voting rights.
Akhil and I had lunch the other day, and we had a long discussion about this very question you're asking. So let me add and do a little addendum to what Akhil said.
Please.
After you grant the vote, right, after the vote has been granted, then the 14th Amendment plays out somewhat differently. Because the 14th Amendment can require that you have equal treatment in fundamental rights. And so once a fundamental right has been granted, the 14th Amendment might require equality in how that right is administered. You also have a Republican form of government clause, which requires that majorities be able to get their way, and requires that temporary majorities not gerrymander or gerrymander, whatever your preference is, in a way to keep themselves, entrench themselves in power, right? So that's also, and Congress has the power to enforce that as well. It's also possible, and this is more experimental, and I'd be interested in what Steve Calabresi thinks about it, akin to the kind of argument he was making about women, that the distinction between civil and political equality, which is clearly there in the 14th Amendment and the 15th, becomes increasingly less relevant as time goes on, and you get all of these amendments that expand the suffrage, first to women, and then to poor people, right, and then to people over the age of 18, till finally the distinction between political and civil equality is only relevant for aliens and children, and perhaps a few other groups, but not that many. And so you might be able to say that in our world, after all these amendments, that the 14th Amendment's Equal Protection Clause, right, is quite relevant to many issues regarding voting.
And that's intergenerational holism of, an interesting sort, and, it's debatable, but it's serious. And Steve did it on one side with Adkins in the 19th Amendment, and Jack just did it over here. One other example of that, let's take Section 2 of the 14th Amendment. Here's what it says. When you disfranchise certain folks, you pay a penalty, your state does, in the House of Representatives and the Electoral College. It says when you disfranchise males. Now, does it still mean male after the 19th Amendment? It says when you disfranchise people over 21. Does it still mean 21 after the 26th Amendment that's about the 18-year-old vote? Those are very interesting intergenerational synthesis, holistic methodological questions for serious originalist textualists.
I had a holistic interpretation question growing out of the citizenship clause that I wanted to ask Jack and Akhil about, which is the citizenship clause is followed by the privileges or immunities, due process, and equal protection clauses, which begin with the words "no state shall," and the citizenship clause is arguably general language that is then made more specific by that second sentence. Would that suggest that perhaps there is a state action requirement and that it's wrong just to read the citizenship clause as overcoming state action, given that the more general expression is followed by 3 specific clauses preceded by the no state shall language?
Used, Steve, the same technique that you used in your very excellent presentation. The Civil Rights Act of 1866, you see, isn't just limited to estates. You know, it has application in the territory, so that's already saying the federal government is bound by this idea of citizenship, and I would say equal citizenship. And what it means to be a citizen is to have ipso facto, as a lawyer would say, certain privileges and immunities vis-a-vis the federal government. Now, it needed to be specified when it came to states because of the rule of Barron versus Baltimore, but that's already what we call in reverse incorporation. The first sentence is about an equality norm. Dred Scott says blacks can't be citizens because they're not respected by white people, not by just white governments. Blacks have no rights which the white man is bound to respect, and that's understanding that citizenship exists in a social register and not just a mere governmental one. It's about public spaces, town squares, and the rest, and so Congress may at least have the power to help define what some of those are.
Just to continue that, though, for a second, part of the reason that the 14th Amendment is concerned with the citizenship of African Americans is to make it clear that Article 4, the Article 4 privileges and immunities clause ought to have applied to free African Americans in southern states. So the concern was particularly with the denial of citizenship to African Americans because it would take away their Article 4 privileges and immunities, and therefore the granting of citizenship in the first sentence of the 14th Amendment, followed by the privileges or immunities clause, would rectify that wrong.
But not in territories. It wouldn't fix it in territories.
I want to say something specifically about the idea that the 13th Amendment and the first sentence of the 14th Amendment don't have state action requirements. And that is something, may or may not be true, but it can't be read off from the fact that they don't say no state shall. For example, I'll use the 13th Amendment as the example. The 13th Amendment says slavery and involuntary servitude shall not exist. If you think that, and this is the point that then requires thought and analysis and research, if you think that slavery is entirely a legal phenomenon, then to say there is no slavery is to say something about what governments can do. So it indirectly has what sort of in Supreme Court language you could call a state action requirement. The Supreme Court says it doesn't have a state action requirement, but what they mean there is something more substantive than just it doesn't say no state shall. What they mean to say is that certain even illegal private actions could nevertheless constitute slavery or involuntary servitude. If you think that isn't true, if you think slavery has to be a legal status, then in effect, again using sort of the rough way the Supreme Court talks about these things, then in effect there's a state action requirement in the 13th Amendment. So whether there is or not is, again, it's a substantive question of interpretation, much the same is true with respect to the citizenship clause. Whether you think that's something that you could describe as having a state action requirement depends on what you think is the legal content of citizenship and what are the consequences of establishing somebody as a citizen.
And it may also matter whether we're asking the question about the self-executing meaning of the provision as judges should enforce it. They always think when they do it, it's self-executing or something, versus the congressional enforcement. As Jack reminded us, an earlier provision of the Constitution just in effect says no state shall. It says no state, no free soil state, shall free a fugitive slave. And yet Congress, and doesn't say Congress even shall have the power to enforce that. And that's in Article 4, the Fugitive Slave Clause. And right next to it, the Full Faith and Credit Clause says, no state shall do certain things, and Congress shall have the power to prescribe the effect. And yet, even though it doesn't say Congress shall have the power, and it just says no state shall when it comes to fugitive slaves, Congress in 1793 and again in 1850 passed statutes that regulated private persons, slave masters and slaves, and created rights of recaption and all the rest, and were upheld by the Supreme Court. And so the Congress, playing by these rules, said, well, we've actually been clear enough that Congress has power to do the same thing for the former slaves that Congress did for the former slave masters.
Okay, thank you. We have about 10 minutes, so we have two more questioners.